Mayor Spencer, members of the City Council, I'm Alicia Guerra with Buckhalter Niemer on behalf of the applicant. I'd like to address a couple of the legal comments that were raised this evening because I think there's a little bit of confusion about what the law says compared to what people have claimed that the law says. Specifically, regarding the general plan consistency and density bonus issues, I submitted a comment letter to address some of the comments regarding density bonus and how the density bonus issues or the density bonus was calculated for the project. The staff report did an excellent job, and Mr. Thomas's summary of the density bonus requirements also appropriately addresses this. But I would like to note there just seems to be some confusion that somehow Encinal Terminals is taking credit for city-owned property, and that has not been the case. And state law is very clear that the property that is the property owned by the applicant at the time the application is filed is when you calculate density bonus. If you did it at the end of the process, that would kind of defeat the purpose of requesting density bonus, because then as long as you keep adding in conditions and obligations to do dedication of land, then you could never achieve density bonus requirements. And the state law is very clear that the intent is to maximize affordable housing, to maximize housing through density, and the way in which it was calculated as demonstrated with the survey of the property demonstrates how we got to the 589 dwelling units. Secondly, there's been a lot of confusion about the CEQA process that applies to this project. I submitted a comment letter to address some of those concerns earlier this afternoon. I'd just like to say that the city has required 2 EIRs in this case for this project, not an addendum, not just an initial study. And through that whole analysis, yes, there have been changes to the project, but those changes have actually further lessened the significant impacts that were already found to be mitigated to a less than significant level. And to the extent, as Mr. Thomas pointed out, there are traffic impacts in this community that are regional and cumulative in nature that can't be addressed through just this project. This project has actually gone above and beyond to address that mitigation. So those are reasons for changes, but it doesn't mean that the CEQA document is inadequate or ignored the issue. Separately, I'd like to address CAD law. There's some confusion about that. The Beverly Act actually establishes very specific provisions regarding how you conduct maintenance through what's established in the plan of control and the GAD budget. There are contingencies built in there. At no time, whether the council is the GAD board of directors or some other entity, at no time is the city's general fund ever attached for purposes of maintenance. With that, if anyone has any questions, I'd be happy to answer them. Thank you.
Thank you, Chris Austin, and then Brian McGuire, and then Christopher Buckley.
Good evening, council and staff. My name is Chris Austin. I'm with Development Planning and Financing Group from Sacramento on behalf of the applicant. So I want to add a couple comments on the funding mechanisms that are being proposed by staff and the applicant. There have been about 10,000 CFDs formed in California since the early 80s to pay for routine maintenance. Not one of them has been overturned by a Prop 218 election. It's theoretically possible, but to date has never happened. So I want to put some calm in those fears that this mechanism could be overturned. What's important is that we get a good budget, we get a good analysis of what it costs to pay for the routine maintenance. And if we do that, there should be no fears that under routine maintenance that this project would pay for itself in spades. I want to applaud the city and the applicant for agreeing to the GAD because that handles catastrophic events, the what if, and all those things. So you've got extra securities, you've got normalized maintenance for the CFD, which has never been overturned in California, and you've got the catastrophic insurance. So both of those mechanisms is a prudent thing for both the city and the applicant to agree to. So you should be rest assured that from a procedure and a policy and agreement, you're doing everything you can to ensure this project pays for itself under normal circumstances and catastrophic. Other than that, we can't do any more than that. So thank you.